Form 18. Request to Registrar to sign judgment against defendant. When do you use a Form 18? If you have lodged a Form 3, minor civil action claim, the defendant has 21 days to respond by lodging a Form 4, defence, or a Form 5, a counterclaim, with the registry. If they have not done so, you can use a Form 18 to apply for a decision in your favour without the need for a court hearing. By doing this, the claim will then become a judgment of the court and can be enforced in the same way as a decision given by a magistrate after a trial. The defendant can still ask the court to set aside or discount a judgment given after lodging Form 18. However, the court must first be convinced that the defendant had a valid reason for not responding with a defence within 21 days, and that they also have a good chance of defending their case. Form 18 also has other purposes. A Form 18 can be used to force the other party to attend hearings or order the other party to pay a debt. This video does not cover using the Form 18 to issue a warrant. If you need to do so, we suggest you consult a legal professional. Where do you find a Form 18? To find a copy of a Form 18, visit courts.sa.gov.au. Click on Forms, Fees and Rules on the left-hand side of the page. Click on Magistrates Court in the middle column labelled Forms. Then proceed to Civil Forms. Then select Form 18. This form is labelled Request to Registrar. Alternatively, see the link below. You can fill out this form on the internet, or you can obtain a form from the registry, which is an office located in the Magistrates Court. How much will it cost to send a request to the registrar? The court charges a fee to lodge a Form 18. This fee changes yearly. For further information, please refer to courts.sa.gov.au. Will you need any other forms or documents? Along with the Form 18, you will need to prove to the court that a Form 3 has been served on the defendant and that the defendant has not responded for at least 21 days. How do you fill in a Form 18? Registry. Here, you need to fill in the details of your local Magistrates Court registry. You will need to include the action number that you were given when you filed your Form 3. Judgment creditor. The judgment creditor is a term for the person seeking the judgment. Therefore, this is you. It is very important that you write your full name in clear writing. Judgment debtor. The judgment debtor is a term for the person against whom you are seeking a decision. For example, the person who you served a Form 3 on. This person is commonly referred to as the defendant. It is important to include their full name, address, and date of birth. To complete the form, please select the relevant boxes below. You can tick multiple boxes if they are applicable to you. Sign judgment. By selecting Sign Judgment, you are asking that judgment be signed, this means a decision be made, in your favour. You may want to select this option if, for example, the defendant has defaulted on their payments, or they have not responded to your Form 3. Investigation summons. If the individual from whom you are claiming is a person rather than a company, an investigation summons is a court document that requires them to attend court for a court date, to investigate their financial situation, and to consider whether they are able to pay the debt, and if so, how it will be paid. This is known as an investigation hearing. Examination summons. If the debtor has defaulted payments that were ordered under an investigation hearing, then you can select examination summons, which is a court document that requires them to attend court for a court date where they must explain why they have defaulted payments. This is known as an examination hearing. The court can make orders for the defendant to pay the debt or to pay it by installments. The other Form 18 processes are more complex, and as mentioned earlier, we advise you to consult a legal professional before requesting a witness summons. Finally, you are required to date and sign the document. What next? If you have gone through the process of filing a Form 18 for a decision to be made in your favour, and the other person has still not paid the debt, after an investigation and examination hearing, then you have the option of asking the court to authorize the sheriff's officer to seize the other person's goods or property in order to pay the debt. This is known as a warrant of sale. You can only tick this box, warrant of sale, where there has been an order for warrant of sale by a magistrate. Refer to the Debt Recovery Handbook that Legal Services has issued. It is available on their website. For more information about a warrant for sale, please refer to the Legal Services Commission website or see the link below.